federal judge in the state of Illinois ruling in a case concerning a non-citizen and firearms. What's the ultimate outcome? Well, let's take a deep dive here. I'm Greg Bishop. Thanks for hanging out. Bishop on Air each and every weekday morning, where we take a look at what's going on in and around the area, especially when it comes to the Second Amendment and Illinois. And we also look beyond the state because there's tons going on elsewhere. But one thing that we do is we take a look at litigation, court action, what happens in the courts when it comes to the Second Amendment. Of course, this week we've got some deadlines that are coming up for that Southern District of Illinois case about Illinois' gun and magazine ban. So that case is still proceeding. You've got the litigants in that case having to tell the judge more detail about discovery and what kind of expert witnesses they believe that they are going to bring to the case when they tackle the gun ban on the merits. So that case in the Southern District still very much ongoing, and we'll be watching that for you as that continues to play out. But we've got this case out of the Northern District of Illinois, and this case apparently started back in 2020. So I want to bring this up so we can kind of just get an idea of what this case is all about. So in the Northern District of Illinois federal court, you've got Herberto Carvajal Flores, where the United States is going after that individual, and it says that the defendant is charged with possession of a firearm while illegally or unlawfully in the United States in violation of federal law. On April 13th, the court denied the defendant's first motion to dismiss the indictment. On December 19th of 2022, this court denied the defendant's second motion to dismiss the indictment on Second Amendment grounds in light of the recent U.S. Supreme Court's New York State Rifle and Pistol Association v. Bruin case. Before the court is the defendant's renewed motion to dismiss in light of the Third Circuit's recent decision in Range v. Garland and the Seventh Circuit's decision in Atkinson versus Garland. For the reasons below, the court grants the motion to dismiss. So it goes into the background saying that the defendant contends that he received and used a handgun for self-protection and protection of property, and because of the defendant's citizenship status, he was charged in violation of the law, which prohibits a non-citizen who's not legally authorized to be in the United States from possessing in or affecting commerce any firearm or ammunition, or to receive any firearm or ammunition which has been shipped or transported in interstate or foreign commerce. So the defendant's criminal record reflects no felony convictions. On February 26th of 2024, pretrial services issued a pretrial release status upon the defendant. The report found the defendant has consistently adhered to and fulfilled the stipulations, conditions of his release, and it goes on. So it talks about the legal standard of this particular law, discusses the motion to reconsider on a variety of other various background elements of the law. The defendant asserts that the Third Circuit's recent decision in Range v. Garland and the Seventh Circuit's Atkinson v. Garland case signify a change in law warranting dismissal of the indictment against the defendant. The government argues that the defendant's motion for consideration must fail because neither of the two cases upon which the defendant relies adversely affects this court's earlier decision to uphold that section of the law. While the court agrees that Range is not binding on this court, the Seventh Circuit's holding on Atkinson warrants discussion. It goes into a discussion about that particular case, and guidance from the Seventh Circuit proposed a set of interrelated, non-exhaustive questions that may help focus proper analysis. And it goes through those questions and the detail of the various legalities in all of this. So not to get too much into the weeds here, but you've got the Second Amendment analysis. It says, in Bruin, the Supreme Court established a framework for analyzing whether a challenged firearm regulation violates the Second Amendment. First, Bruin instructs courts to determine whether the Second Amendment's plain text covers an individual's conduct. If it does, the conduct is presumptively protected, and the government bears the burden of demonstrating that the challenged regulation is consistent with the nation's historical tradition of firearm regulation. This court previously held that the defendant's conduct is covered by the plain text of the Second Amendment. Nothing has occurred that would cause the court to depart from its prior ruling. Although the Second Amendment's plain text presumptively protects firearms possessions by undocumented persons, that does not end the analysis. Under Bruin, if the government can show that the felon disposition statute is part of this country's historical tradition of firearm regulation, then the statute survives. Thus, this court will reanalyze the historical tradition of Atkinson's guidance. So it goes on to talk more about this analysis, and it says the court turns to the defendant's as applied challenge to the law. This is, of course, when you look at something that's on the face, if it's facially applied, it's saying that the law itself is unconstitutional before it's applied to anybody. But as applied means that you're challenging the law as it's been applied to an individual, in this case, the defendant, who's a non-citizen. So the court found that the British loyalist example in the untrustworthy adherence to the law historical analog contained an exception allowing British loyalists to sign loyalty oaths. This exception necessarily requires an individual's assessment to determine if the former British loyalist is so untrustworthy or dangerous that they should be barred from possessing a weapon. The court also determined that based on the government's historical analog, where exceptions were made that allowed formerly untrustworthy British loyalists to possess weapons, the individual who fell within the exception were determined to be nonviolent during their individual assessments, permitting them to carry firearms. So it goes on to analyze more about that historical analog. The government, they say, argues that the defendant is a non-citizen who unlawfully presents in this country. The court notes, however, that the defendant has never been convicted of a felony crime, violent crime, or crime involving the use of a firearm. Even in the present case, the defendant contends that he received and used the handgun solely for self-protection and protection of property during a time of documented civil unrest in the spring of 2020. Additionally, pretrial service has confirmed that the defendant has consistently adhered to and fulfilled all of the stipulated conditions. So it goes on, it says, thus the court finds that applied the defendant, it's unconstitutional. So again, the court finds that the defendant's criminal record containing no improper use of a weapon, as well as the nonviolent circumstances of his arrest, do not support a finding that he possesses a risk to the public safety such that he cannot be trusted to use weapons responsibly and should be deprived of his Second Amendment rights to bear arms. Again, this court finds that as applied, the defendant, this law is unconstitutional. So the conclusion: the non-citizen possession statute violates the Second Amendment as applied to this individual. Thus, the court grants this individual's motion to dismiss. So that means that just for this individual, the way the law was applied, the non-citizen, prohibitor for individuals having a firearm, that non-citizen issue applies to this person. What's interesting here is this case could be used in other challenges of different types of regulations against individuals. One that's brought up here all the time is the firearm owner ID card, and that's the FOID card in Illinois. Is there any analogous law back in the founding era that reflects something similar to the FOID card? Some would argue no, but you've got this ongoing issue in this particular case that was late last week when it was essentially final judgment, the law as applied to that defendant, a non-citizen in Illinois, being unconstitutional. So fascinating to see that. Wanted to get that out in front of you guys, something that might interest you and have you thinking a bit this morning. So wanted to throw that out there for you here with Bishop on Air. All right, be sure to like, subscribe, hit that notification bell. Join me each and every weekday morning with Bishop on Air. Don't forget, go and hit that subscribe button for Illinois in Focus. If you want to get a weekly update of what's going on at the Illinois State House and analysis of the news, myself and the Center Square's Dan McCaleb, we discuss that every week. So search your podcasts player for Illinois in Focus. If you listen to stuff on Spotify, search Spotify for Illinois in Focus and check out that weekly podcast. All right, big things there. So each and every week we put that out with the Center Square, so make sure you make that happen, and check out the centersquare.com/Illinois for regular updates as well. All right, it is Bishop on Air. Plenty more to get to here each and every weekday morning.